Compounding of offences. This is again a very important segment of criminal law. Okay. So compoundable offences are the offences that can be settled through mutual agreement between the parties involved. So in these cases, the complainant agrees to drop the charges against the accused, leading to a resolution of disputes without a full-fledged trial. So they want to compromise, they don't want to further try the case. Okay. Such offences are distinguished from non-compoundable offences. So there are two kinds of offences: compoundable offences, non-compoundable offences. Compoundable offences are those kinds of offences in which you can compromise. Non-compoundable offences are those offences in which you cannot compromise. Compoundable offences are less serious offences. Yeah. So while more serious in nature and does not allow any kind of settlement. Now, nature of compoundable offences. So for an offence to be considered as compoundable offence, it need to have certain characteristics. For example, the severity of offence must not be extremely high as a compoundable offence. Compoundable offences are typically of private nature. Private offences negatively affect an individual's rights and identity. These offences should not harm the general public and should not be against the well-being of the state. So offences like rape, murder, dacoity are extremely serious in nature and therefore it cannot be resolved through compromise. Now, offences that does not require the approval of the court. So according to 359(1), the offences punishable under this section of Bharatiya Nyaya Sanhita specified in the first two column of the table may be compounded by a person mentioned in the third column of the table. For example, uttering words etc. with 300, the person whose religious deliberate intent to wound feeling are intended to the religious feelings to be wounded. So all these offences are directly you can compromise. And then offences that require the approval from the court. So the offences punishable under this section of Bharatiya Nyaya Sanhita specified in first two column of the table, that is specified with the permission of the court before which the prosecution of such offences is being carried out. So this is only applied, this compromise is only allowed with the permission of the court. If, for example, if you have caused miscarriage, so in that case you can compromise, but the permission of the court is required. Now 3. When an offence is compoundable under this section, the abatement of such offence or attempt to commit such offence or when the accused is liable under subsection 5 or subsection 3 of 188 of BNSS may be compoundable in like manner. Now, a scope of compounding and assistance. So where the person who would otherwise be competent to compound an offence under this section is under the age of 18 years. Or has intellectual disability requiring higher support needs, or is a person with mental illness, or any person competent to contract on his behalf may, with the permission of the court, compound such offence. So if the person is a minor, in that case their guardian can compound.
Yes, ma'am.
So when the person who are not otherwise competent to compound an offence under this section is dead, the legal representatives will be able to compound the same. Now, limitation on compounding during trials and appeals. So when the accused person have been committed for trial or when he has been convicted and the appeal is pending, no composition for the offences shall be allowed without the leave of the court. So if the matter has already been heard and the matter is in appeal, in those cases compounding has very little effect. Now, authorization of compounding through legal channel. A high court or court of session acting in the exercise of its power of revision under section 442 may allow a person to compound any offence which the person is competent to compound under this section. Now, restrictions on compounding within prior conviction. So no offence shall be compounded if the accused is by reason of previous conviction liable either to enhanced punishment or punishment of different kind. Now, what is the effect of compounding of offences? So the composition of an offence under this section shall have an effect of acquittal of the accused with whom the offence has been compounded. So for example, if you have compounded with of an offence, means that person is acquitted, that person is released, that person is found to be not committed the offence, or that person is not guilty. Okay. Now, what are the conditions for compounding? So no offence shall be compounded except whatever is provided under these sections. In the case of Biswavan Das versus Gopan Chandra Harsika and others, A 3-judge bench led by G.K. Mittal concludes that if a crime impacts the complainant in personal capacity, the appropriate resolution for such crime could potentially be received through compounding. Okay.